matters of significant interest. It also aims to foster the strengthening of bonds between the legal profession and members of the general public, as well as to enhance public trust and confidence in our justice system. Each year, as part of our series of events for Law Week, the Bar Association tries to host a public lecture on an area of topical interest. We have had in the past the privilege of having such esteemed speakers as Mr. Timothy Antoine, Governor of the Eastern Caribbean Central Bank, Mrs. Karen Nunes Teixeira, family law expert and former senior lecturer at the UWI Cave Hill campus, and the Right Honorable Sir Dennis Byron, former President of the Caribbean Court of Justice. Today it is our honor to have with us the Honorable Mr. Justice Eddie Ventos, one of our resident High Court judges for the St. Kitts Circuit. He will be presenting on the topic, Creators, Carnival, and Copyright Infringement, Time to Face the Music. When we thought of the timing for Law Week 2019, we considered that it would be right around the time of the launch of the National Carnival, what we affectionately call Sugar Mass. And in fact, the official launch did take place last week, Friday, of Sugar Mass 48, just the day before Law Week began. So we believe that the lecture today is very timely, and we think that amidst all of the fun and frolic of Carnival, it is important that we remember that there are legal issues that can arise and intellectual property concerns that arise. And as I said, Law Week is about raising awareness and educating the public. So that is how we thought about the topic. And when we thought who should deliver the topic, Justice Eddie Ventos was a no-brainer. Justice Ventos literally wrote the book on Caribbean intellectual property. He has published a textbook called Commonwealth Caribbean Intellectual Property, and so this is his specialty, and we look forward excitedly to hear from him. And at this time, I would invite us so that we can all ensure that we all enjoy the night, the event tonight. I would ask us to ensure that our phones are on silent or on vibrate. We are currently streaming live on Facebook via the St. Kitts and Nevis Bar Association's Facebook page. We also are pleased to have ZIZ here with us, and we say a huge thanks, of course, to Chameleon Media for sponsoring the live broadcasting of our event on social media. We also, I understand, are streaming on the National Carnival's Facebook page and on YouTube courtesy of Chameleon Media. At this time, I will call on Pastor Dr. Gums to invoke the presence of God as we proceed this evening. Pastor Gums, please stand.
Good evening, ladies and gentlemen. I adopt the protocol. Please permit me to adopt the protocol that has already been established. Let us pray. Almighty God, our Heavenly Father, tonight we are here, O God, as part of its series of events for Law Week 2019 of the St. Kitts and Nevis Bar Association. Almighty God, I pray in the name of Jesus, Lord God, that you, oh God, will continue to be in our midst. I want to thank you, Lord God, that even at this forum, we are careful, oh God, to acknowledge your presence, because without your presence, oh God, we are nothing. It's not by our might, oh God, it's not by our power, but it's by your spirit, oh God, why we are here tonight, seated in this room, standing in this room, oh God. Mighty and everlasting God, as judge, as the Lordship Honorable Justice Judge Ventos is about to bring this lecture, oh God, I pray, Lord God, that we will be edified. I pray, mighty God, that we will be blessed and enriched by such wealth of knowledge that will be given to us this evening. Bless us all in this room, in no other name but the mighty and precious and wonderful name of Jesus.
Could I ask that we remain standing as we will have the national anthem performed by Miss Independent, our national Senior Calypso Monarch.
Good evening. O land of beauty, our country where peace abound, thy children stand free on the strength of will and love, with God in all our struggles. St. Kitts and Nevis be a nation bound together with our common destiny. As stalwarts we stand for justice and liberty, with wisdom and truth. We will serve and honor thee. No sword nor spear can conquer, for God will sure defend. His blessing shall forever to posterity extend.
Okay, that's our back-to-back Senior Calypso Monarch, and by the way, she's the first female ever to win the National Senior Calypso Monarch, and we can clearly see why. Thank you so much, Miss Independence. At this time, I would like to acknowledge the presence of the Honorable Mr. Justice Trevor Ward, QC, Resident High Court Judge for the St. Christopher Circuit. Welcome, Justice Ward. Without further ado, I will call on Ms. Jeanne Williams, who is the Acting Registrar of the Intellectual Property Office, to come and introduce our guest speaker this evening.
Adopting also the protocol established by our chairperson, but of course recognizing the presence of the Honorable Justice Trevor Ward and Honorable Justice Eddie Ventos. Justice Eddie Ventos is a High Court judge of the Eastern Caribbean Supreme Court assigned to St. Kitts and Nevis, the St. Kitts Circuit. He is a former professor of law at the University of the West Indies, Faculty of Law, Cave Hill campus, where he taught for 12 years. He has published over 70 publications and 3 books, including Commonwealth Caribbean Administrative Law, published in 2012. Before returning to the Caribbean, Justice Ventos trained as a solicitor at Slaughter and May, the most prestigious law firm in London, United Kingdom. Justice Ventos holds an LLB with first-class honors from the University of the West Indies, 1999, an LLM with first-class honors from the University of Cambridge in 2000, and a doctorate in philosophy in intellectual property law from the University of Oxford in 2005. Ladies and gentlemen, the Honorable Justice Eddie Ventos.
That's a bit. Good evening, everyone. it's a bit dark. I can't see anybody's faces. I think the middle light, I think it blew off or something. Yeah. Okay, as you can see, well, first I'd like to thank the Bar Association for the invitation to present this lecture as part of Law Week. And the topic, as you can see here, is Creators, Carnival, Copyright Infringement, Time to Face the Music. And I quite like the topic. At some point I actually thought I did it, I realized I didn't. It's a really, really good topic. And when you look at it, you say Creators, Carnival, Copyright Infringement, Time to Face the Music. So you look at what are the things that are protected by copyright, creators, what are the things that are protected in Carnival relating to copyright, and what amounts to infringement. And then you say, those persons who infringe, of course there's a nice play on the word music, time to face the music. There are consequences for infringing copyright. A lot of people don't especially appreciate that an infringement of copyright is a criminal offense. So those of you who say, well, I can stream this movie online on certain websites, or listen to music or download music without paying for it, you're actually all committing criminal offenses. So you may find yourself either before me in a civil action, or you may find yourself before Mr. Justice Ward in a criminal action, prosecution. Okay, so the Carnival Industries, and I'm identifying various elements of it, and of course, you may have other ideas. So you have steel bands, carnival music, you have calypsos, you have etc. The works of mass, the designs that you see of the persons on the road in the various pageants, etc. And of course the pets. These pets are now very elaborate. They have their own themes, etc. And of course carnival pageants. And we'll be looking at what are the intellectual property, well, what are the copyright elements that feed into those. And of course, we have, of course, steel band. And can anybody identify what steel band is this? Or this is? Well, I didn't make a note of it, so I thought maybe when you told me the name, it'll jog my memory. But one of the local bands here, and I got this photo. I don't know what his name is. Bunton. Okay. It was quite difficult finding photographs of Carnival here. Well, appropriate ones. There are a lot of photos that I could not exactly put them up. And that's one of the most decent ones. I think I was in, I don't think it's here, it's a yes, Carrie Fester, yes. Yes, I think that's probably, out of all the photos I saw, that's probably the only one I could really put up without creating scandal. And of course, you have your pageants. And I thought we could go back into history. Anybody here might know some of these persons here? That's back in 1974. And of course, let's not forget, 72 Center Street. And of course, the winner, I think, goes to, anybody here remembers Carnival Queen 1973? It's only a few years ago. Okay, so, and of course these are the feds, they have the various, well, I don't want to dwell on this because it's an upcoming fed, I'm not going. Okay, the various sectors impacted by Carnival: radio, television, the press and literature, advertising services, and legal issues. We're going to focus on copyright, but there are lots of issues relating to Carnival, artist contract, recording and publishing agreements, image protection, branding, financing. Those bands are expensive, and they cost a lot too, as I'm sure some of you know. Of course, the various types of intellectual property, copyright, which we'll be looking at in more detail, protects the expression of ideas, patents protects inventions, trademark protects words, industrial design designs, passing off is the alternative common law action for trademark, and of course, confidential information. So why is it necessary to protect intellectual property? It is essentially to prevent others from taking unfair advantage of the original works of authors. If you haven't spent the effort, time, and money, you ought not to derive the benefits. It therefore prevents free riding. And of course, if persons are able to use your copyright material without paying, then of course it would result in a reduced incentive for those persons to create, because you'll not be able to recoup your investment. And of course, those creators might not wish to provide access to those works. So therefore, copyright essentially attempts to provide a balance between access and incentives. The access, well, let's go with the incentives first. Incentives to give a creator, an author, a monopoly over the way in which they've expressed their work for their life and 50 years. We'll come to this later. But what it also does, it allows access, because there are various exceptions in the copyright law which allows persons to use those works in creating new works. So it is finding that balance between allowing creativity to prosper, but at the same time ensuring there are incentives for those persons. So copyright owners therefore have the right to control the economic and commercial activities related to their works. So they control therefore the access to the public of those works. And of course, it costs a lot in time, effort, and labor to create those works. But copying is cheap. You create, back in the old days, we had the DVDs. Remember everybody buying the DVDs by the road? Nobody buys DVDs by the road anymore. In fact, you don't see them anymore by the road selling DVDs. They're still there? Oh yes, by KFC area there, yes. Every time I pass that, I'm like, But I'm sure none of you purchase those DVDs. I would not imagine you would. And of course, for the copying, easy. But of course, digital copying. You send a video, you send an MP3 file, you can send it to every single person in your WhatsApp list. You can send it to your entire, you can put it online, available to everyone. So reproduction is easy, whereas in the days you'd have to buy the CD, get a cover, expend money. But right now, it costs nothing to reproduce. Okay? So of course, the revenues generated may not be sufficient to recover. If as a result of those copying, the author cannot recoup his or her investment, it may mean that they cannot cover the cost of producing that work. Okay? So it is essential to ensure there's a balance between information production and information dissemination. And so copyright law therefore should provide incentives to create those works. And some persons have questioned, is the economic argument justified? Do those authors create those works because they want money? Or they just want to create? And secondly, well, is it not sufficient to give them protection for their life? Why must you give them their life plus 70 years? They're no longer there. Or you have countries, for example, Jamaica, 2 or 3 years ago, extending. Most countries have 50 years. Most countries have TRIPS Plus, which is 70 years. The law in St. Kitts is 50 years. I'm not sure why they haven't gone TRIPS Plus yet. to 70. But Jamaica went, I think, to 95. And of course, we all know why. Because of Bob Marley. You certainly don't want Bob Marley's music to get into the public domain anytime soon. That's revenues lost. Okay? So of course, there are international influences to the Berne Convention, WIPO Copyright Treaty, and the WIPO Performances Treaty impacting on copyright legislation in St. Kitts in particular. Okay, so we ask the very basic question: what is copyright? Copyright is this: it's a statutory right subsisting in an original literary, dramatic, musical, or artistic works. Of course, there are other types of copyright: sound recordings, films, broadcasts, cable programs, typographical arrangement of a published edition. And that one is really confusing because if, for example, you take a newspaper, the layout of the newspaper is subject to copyright. It's protected by copyright. So a literary work is any work which is written, spoken, or sung. And of course, it includes a table or compilation and a computer program. It covers the work expressed in print or writing, irrespective of the quality or the style. And we'll come back to this point later. The protection of the work is not dependent on the quality. So you can write a bad book. You can create a style which nobody likes, but it is subject to copyright. No one will buy it if they don't like it. But because you don't like it, you can't think that, well, there's no copyright in it. Okay? So there is no need for the work to have any intrinsic literary merit for copyright to subsist. A dramatic work includes a work of dance or mime. In a lot of these pageants, for example, you will see the contestants creating a skit. That is protected as a dramatic work. As long as it is capable of being performed before an audience, it will be protected. A film can fall within the protection or, within the expression of a dramatic work as well. But the courts have made it clear that not all the words to be spoken by the actors are covered by dramatic copyright. Dramatic copyright will also encompass additional stage directions that may affect the performance of the play on the screen and have an overall impact on what is seen by the audience. So dramatic work is not what you see, but it also extends to what you don't see. And we'll see that concept being extended later when we look at music. And we'll be coming back to that point in a while. So stage directions are as much a part of the dramatic work as the plot, character, and the dialogue. A graphic work includes any painting, drawing, engraving, etc. And a musical work consists of music exclusive of any words or action intended to be sung, spoken, or performed with the music. Now, in this case, the court examined what is music for the purposes of copyright protection. And in that case, Dr. Sawkins had researched the works of a composer called Lalande. But of course, that was 2 centuries ago. So of course, the music is no longer subject to copyright. So what he did, and at that time, the music could not be played. He then took the music, made various edits, changes, added new music so it can be playable. He then sought to license it to Hyperion Records, but that negotiations failed. And Hyperion Records decided to produce a CD featuring his versions. Mr. Sorkin contended, well, I'm entitled to copyright in the versions that I have produced. Hyperion Records said, well, no, the music existed already. All you did is make two little changes here and there, and as a result of doing those changes, you're not entitled to the copyright in the music. So Sorkin's brought an action for infringement of copyright and all these moral rights. I will be explaining later on what the moral rights are. So the questions, 4 questions, whether Sorkin's editions were music for the purpose of the act. If they were, whether Hyperion Records infringed. And part of that test of whether infringement is whether or not there was a copy. And of course, whether the moral rights of the author has been infringed. The court held that the effort, skill, and time that Sorkin spent in making the performing editions was sufficient to make them original, even though they were based on the scores that already existed. They were also music within the meaning of that should be music, within the meaning of the UK Act. Just going over some slides here. The court held that the court rejected Hyperion's claim that S had copied one edition. That was rejected. The court held that Hyperion had infringed Mr. Sorkin's moral right by failing to identify him as the author. Now, earlier I showed you some photos. And after I sent the PowerPoint off, I wondered, did I infringe someone's moral rights by not identifying the author of the photograph? What do you think? Did I infringe somebody's rights by doing that? Okay, well, in a few slides, I'll give you that quiz again. So the court then said, well, music is not the same as mere noise. So the sound of music is intended to produce some kind of effect on the listener's emotions and intellect. The sound may be produced by an organized performance of instruments played from a musical score, although that is not essential for the existence of music. And the court made it very clear that what is protected by the legislation is not simply the score, which is the way in which the music can be fixated, which is a record of the musical composition. And it says here, the score is a traditional and convenient form of fixation of music. Because of course, as we'll see later, for copyright to subsist, it must be fixed. It must be in a material form. Although, of course, some copyright cannot be. For example, broadcast. We'll come to that in a bit. But the fixation or on the record is not in itself the music. And the court then goes on to explain what is music. It says there is no reason why, for example, a spontaneous recording, spontaneous singing, whistling, or humming cannot be regarded as music. So if on your way here you were humming, very happy you come into this lecture, or singing away your song that you made up, that can be protected as music for the purposes of copyright. And this is the point that I made a reference to earlier concerning dramatic copyright. It is not sufficient, as the court made clear, to think of music solely in terms of the scores. What is also important is the contribution the person has made to what you hear. So although Sorkin's, in the case I mentioned earlier, did not create all the music, it is his contributions that resulted in you being able to hear anything at all, and therefore he had copyright in his versions. And this case is a classic example of what copyright law protects. there is nothing to prevent someone else to go back to the original Lalonde's works and create their own version. But what you cannot do is to take his version without paying, because it is his effort, skill, and labor that went into the creation of this work, which is now, in which copyright now subsists, and therefore you must get a license, failing which you would be liable for copyright infringement. Of course, I have the music playing somewhere in Bastille. I'm assuming yes. And the building at the back, I don't know what it is. Okay, well, that's music for you. Carnival music. Artistic work, a photograph, and we'll be looking at it in a little bit. We spoke earlier about, and of course, the question of photographs. And everybody, you either go and see Carnival, you by the road, or you're in the park, and you're there with your mobile phones, recording. We'll be coming to recording in a little bit. You're taking photographs. As long as those photographs are for your own personal use, that is fine. But what you cannot do is to take a lovely photograph and then use it to advertise your product, because you'll be infringing a whole bunch of copyright. Firstly, copyright in the designs themselves, which will be coming to in a bit. So these artistic works, of course, as you can see, lots of effort, skill, and labor went into creating some of these designs, and that's one of the decent ones I could have found. And of course, there's this lovely one by this lady here. So of course, copyright would subsist in those. Anyone wishing to reproduce them must approach the person who created it for a license or permission to use it. And in St. Kitts, there's also a right in performance. The performer has the exclusive right to prevent a person from exploiting his or her performance. And when I was told I was being streamed live, I wondered if my performance rights are being infringed. I don't remember giving any permission. My recording rights, it's been recorded. But I suppose the first question is this a performance? And well, it's not a performance. If I probably started dancing there, then maybe yes, you'd have a performance. But no, it's not a performance for the purposes, this lecture is not a performance for the purposes of this act. But interestingly, the legislation gives a person the rights in their performance to prevent a person from recording that performance as well, which I think is, which I haven't seen most other Caribbean legislation. Okay, so the question is, does copyright subsist in what you see below? Just a quick quiz. No answers? You can't see? What is there? Nothing. Exactly. When you go to Carnival, you see nothing. Does copyright subsist in nothingness? I've given you almost a 101 of copyright. Would copyright subsist in nothing? Right, there would be no creation, right? And it must be original. So if you go out in Carnival wearing nothing, then there will be no copyright infringement. Yeah, I realized it was lost in you. What are the requirements for copyright protection? The important thing about copyright, it comes into existence automatically. Whereas for trademark, you must register the mark. For patent, you must apply for a patent. As soon as the work is created, copyright subsists in it immediately. There is no system of registration. As long as it first falls within the category of works that we just mentioned, literary, dramatic, musical work. Secondly, it must be original. And remember, we're not speaking about the quality of the thing. It must not have been copied from somewhere else. It could be similar or even identical to something else, but the point is you must not have copied it from that person. So if, for example, a design is created in St. Kitts, and someone from, let's say Nevis, creates the same design without regard, or none of them having any contact with each other, the fact that they're identical does not mean that there's someone has infringed. They both would have copyright in that work. What is important is that it has not been copied from somewhere else. Now, the question of copying is a bit tricky, because when we look at the infringement later, you can have copying, it's just that you must not copy too much. That's why I'm saying it's a little tricky. You can copy, but just not too much. Because remember, if you hark back to what I said earlier, that copyright allows you to take some of what is there to create your own. So you can take some, but what you create must be original. And of course, it must be tangible or fixed. That's the third requirement. So in terms of originality, there's no need for inventiveness. There's no need for whatever you've created to never have existed anywhere in the world. That's not a requirement. All that is required is it must originate from the author, and that person must have expended skill, labor, and judgment in creating the work. Of course, copying will not create originality, because diametrically opposed to that. And of course, short works, words are not protected by copyright. And of course, one of the reasons words cannot be protected by copyright is that words are the building blocks of language. Imagine somebody have a copyright on the. You know how much money that person will be making? I mean, it will more or less paralyze the English language. So clearly, that's not acceptable. And of course, even though you have trademark protection, the trademark is for the word for a particular thing. So it doesn't preclude you from using that word in ordinary usage at all. Okay? It's just that you must not use it to market your good or service, etc. So the third requirement is must be recorded in writing or otherwise. And of course, this applies in a literary, dramatic, or musical works. Some things are inherently intangible. You can only see the film on the screen. You cannot touch it. You cannot, a broadcast, you can't touch a broadcast. Okay? So there are exceptions to that notion of materiality in copyright. So, duration. 50 calendar years following the death of the author. So, the younger the author, the longer copyright protection would last, because it will be that person's life and 50 years. But of course, this is a statute. The government can change the duration to say, well, we now want copyright protection for 70 years. Or go to the extreme example of Jamaica to 1,000 years. I'm in 95. And sound recordings, films, broadcasts 50 years after it was made. So it's not by reference to the life of the person who created it. Okay? So who is the author for the purposes of the copyright legislation here? The person who creates the work, which is the person who expended sufficient effort, skill, and labor, who sat in their workshop creating the work. Of course, the person who writes a book is the author. Dictation, the speaker will be the author, not the writer. So if while I'm speaking, some of you are writing what I'm saying, I'll be the author. So I will own copyright in what you've written. The only way you will own copyright is if you are reporting in your words what I've said. You're not writing what I'm saying verbatim. A literary work, the author, of course, again, the composer, the artistic work, the artist, the person who's actually created the work. In the photograph, the photographer, sound recordings, the person by whom the arrangements necessary for making those recordings are undertaken, a broadcast, the person making the broadcast. And it's important to identify who the author is, because the author is the person in whom copyright subsists, and copyright is the economic right, and it's that person who has the right, the copyright, and therefore the standing to bring an action for copyright infringement. So understanding who the author is particularly important. Of course, in the carnival bands, the owner or manager, the costumes, the designer, the faces. And although this is beyond copyright, there's an issue about image rights. And that's in the context of persons who are celebrities. So, unless any of you here are celebrities, chances are you would not have image rights unless you can show that there is some commercial element to your face that somebody is exploiting. Okay? And of course, there's the famous case of Rihanna in the UK where Topshop put her face on a t-shirt and she sued. Of course, the court in the UK avoided the question of image rights and looked at it from a passing off perspective, but we're not going to get into that today. Of course, music, the songwriter. Oh, this will be S-O-N-G, songwriter. The bands, and I put the name of bands too because although you don't have copyright protection for the name of the bands, you'd probably have trademark protection instead. So the author is the first owner. So the person who created the work is the first owner and therefore the owner of the copyright. And it's also important because someone may come to you and say, I want you to work in my band. They pay you, as a designer, they pay you for 3 or 4 weeks to give you a salary, or they give you $50 a week. That's too low. That's too low. $400 a week. But you're employed for them for that time in creating those works. If you're an employee and the works are created in the course of employment, the employer is the first owner. Although you will be the author, but the employer will be the first owner if the work is created in the course of your employment. So that's why, I suppose in this context, it's important to distinguish who is an employee or not, because clearly it makes a difference in terms of who owns. And I can very well imagine disputes arising in the context of a band saying, I'm hiring 3 persons to design the costumes. They treat them as employees in the band. And then the band is successful. The persons get their $100 to $200 a week. The person wins the prize of, what's the prize for the band here? 10, 60,000, 100,000? 20,000? US? No? Not so much? Not quite? All right. Okay. But imagine you're paid $1,000 over 3-4 weeks, and it's your designs effectively got the winning 30,000 or 40,000 prize, and all you're left with is that sum. And of course, if you commission the works, the person who commissioned is the first owner. So the person who created the work that is commissioned is the author, but the person who commissioned the work will be the owner. And of course, if two persons create the work, they become joint authors, and they therefore become joint owners. Okay? Of course, the question of ownership, and it's not really proof of ownership, it's really proof of authorship. How do you prove that you actually created that work? And it's important to keep a record of what you're doing. And in the Da Vinci Code case, where Dan Brown, it was alleged that he had breached copyright of this other book. What's the name? I'm sure you know. Oh dear. I know my memory is bad, but the Holy Blood and the Holy Grail. Yes. And it was argued that he infringed copyright because he took the various themes from that book, which he did. But copyright does not protect ideas or concepts. It protects the expression, the way in which you've expressed those ideas or concepts on paper. That's what copyright law protects. And one of the, if you read the case, which is very long, you probably might not bother, one of the ways in which he was able to prove that he created the work was that he had, well, first his wife was doing lots of research for him, but he had the various drafts, his notes that he took from the first stage. He had all his edits, his drafts, all the research that he did. So he was able to provide lots and lots of evidence to show where he started to where he ended. So he was able to prove all those records. And of course, important as well, to be very careful who you share your work with. Because you share it with somebody else, the person takes it out to the market, they start selling it. It's already out there in their name, it's being sold, they made millions. You now want to sue. Well, you're now playing catch up. The public already associates the product with that person. You'll spend, I was going to say years in court, and I realized, well, I probably shouldn't say that. Months in court, getting vindication. So what's important is using confidentiality and non-disclosure agreements. Some people are very hesitant to sign them. They somehow feel that, well, the reason you asked me to sign it because you think I will steal your work. Well, yes. I mean, it's as blunt as that. You have to protect yourself. And if the person does not want to engage you by signing, you have a choice. Either you take your ideas to them, and they're saying, they have a look at it, they say, yeah, I don't like it, you know. And they send you away, and a few months down the road, you see it somewhere else. So the best thing is to protect your works by ensuring that you have those persons sign a confidentiality or non-disclosure agreement. And of course, once you've created the work, how do you reap the benefits of it? You can license it, you can assign it, let somebody else exploit it. So you transfer in the property to somebody else for money, etc., or whatever else you wish. Or you license it either to one person exclusively or to many persons. And of course, if you're having an event, let's say you're having the carnival, either the carnival pageant or the Calypso finals, do you want media accreditation at that venue for the press, photographers, or for persons with internet or television stations? And of course, I think ZIZ live streaming, and I think they're live streaming here too, again. So we've established what a work is, we've established how copyright subsists in the work, we've established who owns it. The question then is, what are the things that accompany ownership? Because copyright is essentially a monopoly which gives the owner a right to prevent third parties from doing certain things in relation to the work. Because you can do nothing with your work, you can just sit there in a box. Fine, that's your right. But what does the law give you? It gives you a right to copy the work, which is called your reproduction right. So no one else can copy that work without your permission. They cannot issue copies of that work to the public, rent or lend the work to the public. So these are rights which come with ownership, which is why ownership is important. And I explained earlier that authorship gives rights to ownership, and in some cases, authorship does not, in the context of employees who create the work in the course of their employment, and commission works. The author is not the owner, okay? To perform or show the play in public, the public performance right, to broadcast the work, or to include it in a cable program, or to make an adaptation of the work. All these are rights which are vested in the copyright owner. So, you have a right to copy the work. A person infringes, primary infringement, if they take the whole or a substantial part of the copyright work. And remember I said earlier, you're allowed to copy someone else's work. What you cannot do is to copy the whole of the work or a substantial part of the work. So if you take someone's musical score, you can take a part of it in your song, but the part you take, you must ensure that that part, in relation to the person's song, is not the most important part. So, if you want to copy, which the law allows, so copying is not a bad thing, in a sense. It's bad when you copy the whole of someone else's work, or a substantial part of it. But of course, the question is always, what is a substantial part? Okay? And of course, there must be a connection between the original work and the infringing copy. What are the similarities? Are there similarities? Are there differences? And what explains the similarities? Are the similarities explained because the nature of the work in question, that particular feature is a feature that all those works would have? Of course, let's take an example of a kind of a costume. They all will have feathers. Well, most of them do. And sequins. Can somebody argue, well, that feather you use there, you have infringed my copyright by having a hat with feathers? Well, you expect a costume to have a hat with feathers, colorful feathers. And they all nowadays it seems to be a one style. So it'll be very difficult in the context of, at least for Carnival, to argue that. But of course, for the Calypso music, well, certainly at a competition, there will be no issue about infringement because everybody's coming up with their own music. The question is, if somebody is using the music without paying at that time. So the question then is, you have to assess both the quality and the quantity. And the quantity may impact the quality, but it may not necessarily be so, because what's important is whether what you've taken is a substantial part of that original work. And as I said earlier, you can take a little bit, but that amount is a substantial part of that original work, and therefore you would have infringed, although you may think, well, you're not taking much, but that's not really the point. So although copyright allows for copying, you have to make sure that you respect the boundaries of what you can and cannot do. And of course, it'll not be immediately obvious to a person where that boundary lies. How much copying can you take without infringing? And I think, of course, it's a judgment call for any of those artists to ensure that, and I think the standard should really be, even if you've copied, whether or not your work is in itself original, it stands out. It's not simply a replica of what has been done before. And I think once you've established that your work is original, the mere fact that you've copied may not necessarily be an issue in terms of infringement. So the factors you look at, the distinctiveness of what is taken. And another point too, which when you look at the distinctiveness is, I mentioned earlier that copyright law protects the expression of the ideas rather than the ideas themselves. The more detailed your idea is expressed in your designs, the more likely it is that if somebody copies those distinct elements, they will infringe. Okay? So if your idea is expressed in very general terms in your work, you cannot prevent someone from having, as I said earlier, feathers. Most costumes come with that. Okay? So the distinctness of what is taken is important. Copyright law protects the expression of the ideas, not the ideas themselves. Secondary infringement. So we looked at primary infringement, the actual copying, etc. If you possess an infringing copy, so your friend gets a CD, he buys a CD at, where they sell CDs here? No, I'm talking about legitimate CDs, where? Walmart? You have a Walmart here? No. Oh. I was like, I didn't know that. Harper's? Okay, let's say you go to Pelican Mall, wherever that is, and you buy your CD for however much, your original CD. Well, let's say original, you buy it from a legitimate source, it's not an infringing copy. You take it home and you burn it. And you give your copy to a friend. Your friend, by possessing an infringing copy, will also be infringing. If you go overseas, you go to China, for example, Taiwan, or the US, and you see some bootlegs or Swan Street in Barbados, or in Charlotte Street in Trinidad. Where's the street? Well, the KFC street in Bastille. What's the name of that street? Okay, Beirut in Bastille. Each country have those streets where you get these things. And you import it, you bring it to another island, you will be infringing if you sell, exhibit, or distribute. So those persons right there are infringing right before all of our eyes. And of course, if you permit your premises to be used for infringing performances, or providing apparatus for such a performance, you will also be infringing. Of course, the section in St. Kitts Act also provides for infringement of performers' rights. If it's broadcast or if it shows in public by means of a recording made without the performer's consent, then that will amount to an infringement. An adaptation is also an infringement. Importing illicit recording of a performance. So you go to a show, which artist was here recently? Is it Buju Banton? Yes. How I know that? Everybody knew that. And I'm sure some of you will rather than enjoying the experience as you should, you probably had your phone recording. Now, that act in itself is infringement because you're recording the performance. Anyone who, if you recorded the performance, you have no right to do so, you will be infringing. Okay? So that would also amount to an infringement. And I found this very curious provision in the St. Kitts Copyright Act. It says, it shall not be an infringement of any copyright in a design, document, or model that records or embraces the design for anything except an artistic work to make a copy. I thought it's very interesting. So you can make, so if you get a design and you create the work based on design, you're not infringing copyright except if it's an artistic work, which I thought was interesting. So we come to facing the music. This is the part where you face the music. Copyright infringement is an offense. Primary infringement, secondary infringement are all offenses. On summary conviction to a fine not exceeding $50,000, which I think is a bit low. But I'm not the criminal judge, so that's fine. And even if I was, I couldn't go beyond the 50 anyway. Or for a term of imprisonment of not exceeding 2 years or both. So you can be fined and imprisoned. On conviction and indictment to a fine not exceeding, oh, that's much better, $250,000. Or imprisonment for a term not exceeding 5 years or both. So those of you who think, well, I want to watch my show Suits, or what are the shows they have on now? What's that? Power? Yeah. Well, I don't know what, I claim not living in 2019 because I don't know about that one. And you say, well, let me Google Power stream live, as I'm sure most of you do, and you're looking at it online, you would be infringing. And in fact, some of these companies are so aggressive in terms of, at least they used to be in the early 2000s. They would monitor universities' servers to see if there's a lot of movement. And of course, you just send one letter to university saying that your students are infringing based on the movement they're seeing, and that will cover the university in terms of monitoring the use of the internet providers. Okay, so I mentioned earlier that you have the moral rights, copyright, and the moral rights. Copyright is the economic right. So even if you, the author, which is the first owner, if you sell your designs, you now have a new owner. Those rights remain with the author. The right to be identified as author. So if you take someone else's design and you put your name on it, you are infringing the moral right, the right of paternity to be identified as author. You take someone's work and a painting, a design, and you treat with it in a way that could be said to be derogatory, you will also be affecting the person's moral right of false attribution. And of course, the right to privacy of photographs and films, and the moral rights, the duration is the same as copyright, life plus 50, except for false attribution, which is only 20 years. So the remedies available to a person, damages for the loss you've suffered as a result of the person's infringement. If you provide evidence that you could have sold 500 copies, or you were selling 500 copies for the last 3 months, and now you're selling 2, your loss is 498. So that's an evidence of the loss as a result of the infringement. The person's going to account for profits. But of course, it all depends on what you think is better. For example, if a person infringes your copyright and your profits have not diminished significantly, so let's say you only lose $10,000. You're making $500,000 every month, but you've seen a reduction of 10,000. But the person, by selling so many copies, they've made 1 million or millions. You can ask for an account of profits that the person has made. So rather than ask for compensation, which you'll only get 10,000 because that's the extent of your loss. If you ask for an account of profits, that person will have to disgorge all the profits they have made as a result. So I think it's best to get advice as to what is the more appropriate remedy. And of course, there's deliver up for the person to deliver up and for those items to be destroyed. Because you certainly don't want them in the marketplace. And certainly if they're not of the same quality, you want them destroyed. Okay? And of course, those remedies, deliver up is also available in the criminal proceedings as well. But in terms of the criminal remedies, one of the major issues is having a virtual complainant. Would any of those companies come to St. Kitts to bring the action? I think in Barbados last year, I can't remember which company it was, Puma. They came to Barbados and they ensured that a prosecution was brought against someone for infringing. And of course, as I said, Swan Street is riddled with all types of infringements under the sun. Of course, there are lots of exceptions and exceptions to copyright infringement, research and private study. If you say, well, I need to watch a particular show because you're researching shows in the US, for example, and you want to research it every week at a particular time, for example. But of course, it must be genuine research and study. It cannot be contrived. Criticism, review, and reporting. You can report, criticize, and review the work, so you have to use the works in order to be able to do that. Instruction and examination, that's also some exceptions. So if there were to be any argument that I use the photographs without permission, which I didn't get permission, firstly, I don't know who I would ask because I just found them randomly online, and I'm sure it would fall within the educational exception. I am presenting a lecture, and therefore I'm not making many. This is not a commercial enterprise. I'm sure it would fall within that exception. That's reading or recitation in public, and yes, playing a sound recording for a charitable organization. So If you want to be able to use someone's sound recording, just register your organization as a charitable organization, and you can knock yourself out. And time shifting. You're allowed, if you have a particular show that comes on at 12 o'clock in the afternoon and you're at work, you can record it, but only for the purpose of playing it later. Not to send to your friend, not to use anywhere else. Just allow you to record it for the purpose of playing it later. That is called time shifting for private domestic use. Not for you to record later and have a big party where you're charging persons to come and watch the final season of Game of Thrones or anything of the sort. That would not fly. And this is my last slide. Thank you very much, everyone. Yes. Oh, there you are. I can see you now. Any questions?
I just want to clarify, you had during the course of the employment,
Yes.
is there a limit to that? Does it mean while I'm at my job from 8:30 to 4:30, or it's as long as I'm employed to leave?
Okay, that'll have to be a little more specific. You have to give me a specific question.
It's you had indicated that
Yes.
the creator, if you create while you're employed to someone,
Yes.
that the owner of that particular bit of work
Yes.
that you created
Yes.
is the employer.
Yes.
So I'm saying, is that while I am, because you use the term during the course of your employment.
Yes.
Is that just during the hours that I'm working for you at this particular building that I execute that work?
Yeah.
Or is it as long as I am, for the duration of the time that I am employed to?
Yeah. If you're employed and you're employed to make a particular design and you go home with it and you continue it at home, that will still be part of your employment. However, if you create a work independent of your employer, then that will not fall within that. But of course, there's a question of were you using the employer's resources? Were you using the employer's other employees to give you assistance? What resources? So it's really factual what exactly happened, and can you see that it is still within the course of employment? Yeah. So all depends on the exact on the facts of the particular case. Yes.
With the statutes on the books throughout the region, what seems to be the problem with the policing?
Beg your pardon?
What seems to be the problem with the policing of these laws? Because they were known. Because I've spoken to police officers who say, well, we don't know how to enforce it. The issue comes down to the police and police being afraid with the laws. Say there's a beach, police officer on the beach. The person is trying to sell my material. He said, I don't know how to enforce it.
Sorry. You tell a police officer on the beach that this other person is infringing your
That
copyright.
has happened.
Yes.
They don't know because they say, well, you have only 12 pieces of work in the city. You have to prove that each is yours, you have to question about that. I can tell this. They don't know how to enforce it.
They wouldn't know how to approach that it is yours. But that's a question of evidence, not a question of.
They say to me, they don't know how to approach it. This guy sells material, gets my feet, they don't know. So if the police say, or the police are they cooperating with these laws? The police department, are they instructed to dispatch clear statutes on how to approach our police dispatch of the town?
Well, firstly, the first assumption I can make is that the police officers are aware of all the laws. And if they aren't, then clearly something needs to be done to ensure that they're aware of it. But in your case, you have a virtual complainant, which is you. So the usual reason why these laws are not, that you don't have lots of prosecutions, is that you don't have a person you don't have Nike coming down to say, well, someone is infringing my copyright. But I can't imagine what the issue would be in relation to your example. The question of, I don't know, do they have the capacity to investigate whether or not the crime has actually been committed in terms of whether there is copy?
Also mentioned Shadow Street in Trinidad. It happens there.
It happens everywhere.
So it's enforcement across the region.
Yes. Yeah. So the question of enforcement revolves around one, public education in terms of letting persons know what their rights are so that they can then bring the prosecution. And secondly, the law enforcement persons knowing what those offenses are. And I think thirdly, the capacity to investigate and have the necessary skills to be able to carry out those prosecutions.
I'm just curious, I have a question.
I saw you immediately and I said, that's all as a question.
Following on from the last speaker's question, because that too has been the experience in Trinidad and Tobago, where artists will tell you that they walk along Frederick Street, Charlotte Street, they see their products, and they are not able to get any redress from the authorities. And it seems to me that it is a question, of course, of training the police officers in this particular area of the law. So I was just curious to find out whether anyone is aware of any prosecution for infringement of copyrights in St. Kitts and Nevis, because in the time that I've been here, I haven't seen any come before me.
Just to say again, Jeanne Williams from the Intellectual Property Office. We actually have had training with the High Command of the Police and the DPP's office as recent as last year. So that is something that we continue to work on. So the police are increasing their awareness of that. In terms of prosecution, we have never seen any cases. And the trademark case from Barbados with Puma, that was actually the first in Barbados.
Yeah. No more questions? Are you shy tonight or something? The A-level?
Question. When an architect produced a design for you and you've paid him, when an architect produced a design for you and you've paid him, does the design belong to you or to the architect after you've paid him?
The architect would be the author and you would be the owner. So the architect cannot then go and give somebody else a design and you're going in some, I'm really struggling with the names of places here. Frigate, yeah, you're driving in Frigate Bay and you're like, but this looks like my house. But it's interesting what will happen with that, because what would you do? Okay, you see, so the architect could have infringed your copyright. What do? Get the person to break down their house? Let me not speculate in case it happens. But yeah, to answer your question directly, the architect would be the author and the person who's paid for it would be the owner. But it's interesting in terms of photographs. You'd get your photograph taken, and most of these places they would want to give you a hard copy. Like, but why can't I get an electronic copy? Suggesting if you want another copy, I'll come back and pay $10 for your photo. Why can't you just give me electronic copy and I can make copies if I want? Yeah, there's some issue about photographs with photographers. They don't like to give, assuming. Yeah, I think the photographer would be. What I think that's interesting about a photograph is that the person taking the photograph will be the author and owner, not you. Which is although there's an issue about your image, so the question is, can they then use your image, which is not a copyright issue, that's an image rights issue, but the photographer would be the, which is why they don't want to give you the electronic copy. They want you to come back. Yes.
Thank you. I've been in discussion with other composers.
Yes, I should have asked before, are you an artist, or are you
I'm a singer, songwriter, recording artist, etc.
What's your name, yeah?
Socrates.
Socrates.
That is correct.
Okay. The reading Calypso King? The former one?
Multi-crowned.
Okay.
You're obviously the former. Yes, I've been in discussion with other composers.
Yes.
And as you mentioned that you can take a portion of an original work, and it was said up to a certain amount of bars.
I didn't say a certain number of bars.
No, that was discussed. I'm looking for clarity.
Oh, that was discussed in your meeting?
Yes, well, brief discussion that you can use up to a certain amount of bars.
Yes.
So I was trying to get clarity if that's a fact, and how many bars of a piece of work can you use in,
Well, I think that's not exactly correct. It's not the number of bars, because you can take 3 or 2 bars, and that
is a substantive
is a substantial part of the original work, and therefore you will be infringing.
Thanks for clarity.
Yes, so that's important. I normally have the habit of picking people, but I will not do that. One more question?
My name is Grace Richardson. I am the licensing agent in St. Kitts and Nevis for ECHO.
Yes.
I noticed near the end of your presentation, you skipped over injunction.
I didn't mention injunctions?
No, you skipped over it. So I was wondering what you can tell us about injunctions.
Yeah, I should not have skipped over injunctions. It's one of the critical. I did mention damages, but an injunction is one of the critical remedies you want in terms of copyright infringement. In that you want to stop what is taking place, so you apply to the court ex parte for an injunction to stop the person from doing what they're doing, to ensure that if they're either importing, to stop it from entering into the market, or stop them from putting it out into the market. So you can apply for an interim injunction, you get it, you have a return date where it's argued, and it's either made final or otherwise. Yeah. So that's a critical remedy. That is, first, you apply for it either as an interim or as a substantive remedy in your copyright infringement action. Yeah, thanks for reminding me.
Good night, sir. Troy Biff Mills, Director of Culture. Very interesting presentation. In relation to King Socrates, I've judged Calypso once or twice, and we as judges have been taught when it comes to originality, it's 16 bars. So I found what you said interesting, very interesting.
Well, you look at originality for different purposes. Originality for copyright law is maybe different for what you look at for originality in terms of judging a competition. So I think it's probably just the concept being used for different purposes. But in the copyright sense, that's what it means. Yeah. Okay, if there are no more questions, I realize the students, and there are many, are they very quiet? Yeah, I won't pick on you as I used to in my Cavil days. I think that's rough. Thank you very much.
Thank you, Justice Ventos, for that stimulating and illuminating lecture on these very interesting issues. We have certainly all learned a lot. I think I can speak for all of us. We've gained a lot from being here today, and we've learned that there are things that some of us may be doing that we do every carnival, we do every music festival, and lo and behold, we are infringing the law and subject to penalties in the hundreds of thousands of dollars. Now, if you're feeling nervous about that, I can put a plug here. We are having a free legal advice clinic on Friday of this week. The general public is invited to come and get free legal advice from members of the St. Kitts and Nevis Bar Association. The venue for that is the Newtown Community Center in Bastia, and in Nevis, it's the Red Cross building in Charlestown. It starts at 10 a.m., and we have lawyers ready and waiting to give you free advice on any issue, intellectual property or otherwise. We have a cultural presentation. The Brotherhood drummers are standing by. They're in position now, and if you give them your full attention, please. Thank you very much. Thank you, thank you. All right, that was the Brotherhood drummers. Thank you so much. Ladies and gentlemen, more information on intellectual property in St. Kitts and Nevis, including all of the laws and educational resources on intellectual property, can be found at the Intellectual Property Office website, That is www.ipo.gov.kn, ipo.gov.kn. And of course, the St. Kitts and Nevis Bar Association website is now live, and it too has many educational resources on it, and that is www.sknbar.org, sknbar.org. It also has all of the information on Law Week 2019 as well. I will now call on Ms. Darian Charles to give the vote of thanks.
Night, everyone. It is with great pleasure on behalf of the Bar Association and the Organizing Committee for Law Week that we extend thanks to His Lordship, the Honorable Mr. Justice Eddie Ventus, guest speaker, for taking time out of his otherwise very busy schedule to share this very informative and enlightening presentation. After this lecture, we are all undertaking, as of today's date, to stop downloading all the music and streaming power on Sunday evening, as we do not wish to end up before you or your brother Justice Ward on the wrong side of the law. His Honorable Justice, Mr. Trevor Ventus, QC, to the Bar Association and the Organizing Committee for Law Week. Sorry, Trevor Ward, sorry. Sorry. To the Bar Association and the Organizing Committee for Law Week for organizing this public lecture and choosing this very topical and interesting issue. To the Assistant Registrar for Intellectual Property, Ms. Jean Williams, for her splendid job at introducing our guest speaker. Acting Registrar, I'm sorry. For her splendid job at introducing our guest speaker. I am sure with the number of persons present here today, you would be visited by a few who would all be seeking to protect whatever works they have now that they are aware of their new rights. Ms. Taliba Byron, Mistress of Ceremonies and Chairperson for Law Week, for her tireless efforts in overseeing the organization of the events for Law Week, in particular this public lecture. Pastor Dr. Vomi Gums, for her very moving opening prayer. Ms. Carissa Willett, reigning National Senior Calypso Monarch, for that poor-raising rendition of the national anthem. To the University of the West Indies, for allowing us to have a venue to host this lecture. To Chameleon Media for its live broadcasting and allowing persons who are unable to be physically present to get the benefit of this lecture. ZIZ Broadcasting for broadcasting the lecture. The Brotherhood Drummers for their very interesting and lively presentation at the end of the lecture. Ladies, gentlemen, and students for attending and making this lecture possible. Also to our valued sponsors for Law Week, the Social Security Board, the St. Kitts Nevis Anguilla National Bank, TDC Business Center, Very Exciting Things Limited, Professional Computing, South Beach Promos, Hosford's Value Mart, Nevis Bakery, Sugar City Adventures, Food Center Cash and Carry, and Underground Heavy Equipment. We thank you all, and we wish everyone a safe journey home.